Hello, everyone. Thank you so much for joining us. I am Ann Albert, the Klatt Family Director for Public Programs here at the Herbert D. Katz Center for Advanced Judaic Studies at the University of Pennsylvania. And I am here to welcome you to our second program in a series of talks on Jewish law and the US Constitution. This series features 8 talks running from last week through the end of February. And it's a series designed to build on the theme of this year's fellowship program at the Katz Center, where we have an international cohort of scholars and residents here, all studying aspects of modern Jewish legal culture. The fellowship theme is broad and global, looking at both Jewish law and its non-Jewish and non-legal contexts. But this series that we're doing on Zoom for wider audiences is more focused, zooming in particularly on the United States to think about interactions between the spheres of Jewish law and Jewish life on one hand, and the American legal system and constitutional law on the other. So these interactions and intersections have been, of course, many and varied, high and low, taking place in innumerable aspects of American culture. Last week, we heard from Professor Noah Feldman about the Jewish identity and intellectual bent and commitments of prominent Jewish jurists. Next week, we'll hear from Professor Suzanne Last-Stone about Jewish divorce cases in US law. In a moment, I'll introduce today's speaker, Nomi Stolzenberg, who's just appeared with me here. Before that, just some quick thanks. We want to extend our gratitude, as always, to the Klatt family and the Harry Stern Family Foundation, whose gifts made this programming possible, to the Katz family and the rest of our board of advisors, and the many other donors who help us to perpetuate Jewish studies scholarship within and beyond the academy, as we do here. I also personally thank all of my colleagues here at the Katz Center who make everything go. Additionally, for this series, I thank very sincerely our partners for this program, the University of Pennsylvania's Carey Law School, and in particular, Professor Tom Baker and Julia Halper, who have worked with us to make these programs available for continuing education in law, continuing legal education credit. So just a quick note for our regular Katz Center attendees, you'll hear me making a few announcements at the start and end of the program for people who are doing this for credit. This is like a professional development program for attorneys. If you're not doing that, you can just tune me out for a second. If you are seeking to receive CLE credit for today's event, now's the moment to listen. Please note that CLE passwords will be announced twice, once now and once at the end. You should write these down and enter them on the digital evaluation form after the event is over. I'm told that that evaluation form is mandatory to receive credit, and the link to it was emailed to you in your confirmation email when you registered for CLE. Please do note that that's a separate registration from the Katz Center Zoom registration. And if you didn't receive that, you can find a link to that form in the chat. If you're only learning about this now and you want credit, it is not too late. You will be able to find information about that if you follow, if you go into the links in the Katz Center's event page for today's talk and the rest of these series. Okay, with that said, the first password for today is issue, ISSUE, issue. Like our other programs, this program is being recorded. It will be posted to the Katz Center's YouTube channel in short order, so you can review it and share it there. As we proceed, I encourage everybody to submit questions anytime throughout the hour using the Q&A function in the bottom of your Zoom window, and I will moderate a discussion after we hear the main talk. Okay, that's enough business. Now, with no further ado, I am really happy. I have the rare pleasure today of introducing someone who's under the same roof with me here at the Katz Center. Professor Nomi Maya Stolzenberg is the Nathan and Lily Chappell Chair in Law as the Gould School of Law at the University of Southern California, and is here in residence at the Katz Center as the Eliane Herbert D. Katz Distinguished Fellow this year. In general, her research spans a range of interdisciplinary interests, including law and religion, law and liberalism, law and psychoanalysis, and law and literature. She's taught in the past at Tel Aviv University, the Hebrew University of Jerusalem, and Columbia Law School, and she helped establish and now co-directs the USC Center for Law, History, and Culture. She's the author of several works that are often cited, including the essay Writing the Relationship Between Race and Religion and Law in the Oxford Journal of Legal Studies. And just a few weeks ago, an essay of hers appeared in a forum on legal theory and Jewish history in the fall issue of the Jewish Quarterly Review that's put out right here at the Katz Center, alongside essays by Noah Feldman and Suzanne Stone, who's speaking next week. There are links to that in the blog on the Katz Center's website if you're interested. Finally, most recently, and to wide acclaim, Nomi has co-written with David Myers the book American Shtetl, The Making of Kiryas, a Hasidic village in upstate New York. This was, among other things, named one of the best books of 2022 by New Yorker Magazine. And it is also the context of that research that we'll be hearing in today's talk. So with that, hand things over to you, Nomi, and I'll see you again after your talk. Welcome.
Thank you so much, Anne, and thank you to everyone for being here to give me the opportunity to share a little slice of a topic that has been an object of fascination to me and to my co-author, David Myers, for literally decades at this point. And that is, and I'm going to have some illustrations, so I'm going to share the screen. That is the village of Kiryas Joel, which is the subject of the book that I co-authored with David Myers, who happens to be my husband, but more relevantly is a scholar of modern Jewish history, which Anne just mentioned. And there are many, many layers to the history and the story of Kiryas Joel. And part of what really fascinates us is that it's really a story about America and what is it about American society and America's legal system, its political system, its economic system that made it so uniquely receptive to the creation of this municipality. And today I'm going to focus on, as I said, just one sliver, one chapter, one episode in the story of this village, which concerns the way in which the question of whether this village is a theocracy was raised and how and why that issue was avoided and indeed has never been resolved. So some of you may already have some familiarity with the village of Kiryas Joel. It's a village in the suburban outskirts of New York City, about an hour drive from New York City. It was legally incorporated in 1977, at which point in time the number of residents numbered in the hundreds. Owing to very high birth rate and really exponential population growth. Today, the population is no less than 33,000. And in 2019, the village of Kiryas Joel, which was formed as a subunit of the township of Monroe, was actually transformed into its own self-standing town known as the town of Palm Tree. The most notable feature of this village is that virtually everyone who lives there is a member of a particular Hasidic group known as the Satmar Hasidim. This is the largest Hasidic group in the world. It takes its name from the town of Satu Mare in Transylvania, where the group was originally founded by the founding Rebbe, whose name was Joel Teitelbaum. So the village of Kiryas Joel means in Yiddish, the village of Joel. It's named after the founding Rebbe, Joel Teitelbaum, and Palm Tree, the name of the newly formed town into which the village has been transformed, is the English translation of Teitelbaum. It means palm tree. So the village was officially formed in 1977 with relatively little public notice. But 12 years later, the state of New York enacted a special statute permitting the town, or rather the village, to establish its own public school district. And that law, allowing for the creation of what's known as the Kiryas Joel Village School District, was subject to a constitutional challenge. A lawsuit was filed claiming that the passage of this statute allowing Kiryas Joel to have its own public school district constituted an establishment of religion in violation of the Establishment Clause of the First Amendment of the US Constitution. Now, I could talk about that case, which is the case that really brought the community to light and public attention and a fair bit of public criticism at length. But actually, what I want to talk to you about today is a less well-known, but I think equally interesting litigation that emanated out of the village that raised some similar issues, but in a somewhat different framing. And that is a case that was brought in initially in the mid-1990s by not an outsider. The previous case was filed by not a Satmar, but a concerned citizen who looked askance at the creation of a separate public entity for members of the Satmars. By contrast, the case I'm going to talk to you about today, known as Chal Haraidim versus Village of Kiryas Joel, was brought by Satmars who are known as dissidents within the town, within the village of Kiryas Joel. So when the village was first formed, the Rebbe, to whom I alluded before, was still alive. He was an extremely charismatic leader, and the community was still relatively small and highly, highly unified. But within less than 2 years after the village was founded in 1979, the Rebbe died. And the Rebbe died, leaving behind no sons, no male heirs. And so his nephew, by the name of Moshe, was chosen to be his successor, to be the new Rebbe. Not everyone accepted the new Rebbe or regarded him as a legitimate successor. This is a familiar story in the annals of religious history. And there we saw the seeds of the beginning of what today is a total schism within the Satmar community. In the 1980s and 90s, the dissension was still confined to a relatively small group of people, but they were becoming increasingly active. And while the initial object of their opposition was the new Rebbe Moshe, in the 1980s, Moshe, the new Rebbe, appointed his eldest son, Aaron, to be the chief rabbi just of the village of Kiryas Joel. So the Satmars, the Kiryas Joel is really a satellite community. The main headquarters, as it were, of the Satmars, as is the case for most, if not all, of the different Hasidic communities that were sort of transplanted after World War II, is Williamsburg, Brooklyn. And there are other satellite communities in Canada and in Israel and around the world. So you had Moshe presiding as the Rebbe over the worldwide Satmar community, and he made Aaron, his son, the chief rabbi to preside over Kiryas Joel. And so the opponents of Moshe also became critics of Aaron, the chief rabbi of Kiryas Joel, and indeed criticisms of Aaron intensified over the course of the 80s and 90s, so that by the end of the 80s, you really had a full-blown dissident movement inside Kiryas Joel, one faction of Satmars feuding against the other. This lawsuit emanated out of that feud, out of that dispute between the so-called KJ, short for Kiryas Joel dissidents, and the KJ establishment. And it originated as kind of a garden variety zoning dispute over this property. If I can switch the slide. Right here, you see pictured, this is 3 Van Buren Drive in the village of Kiryas Joel, which was owned by a man by the surname of Weinstock, who was allied with the dissident faction. And he had applied for a construction permit to expand this was his, or it was a residential home that belonged to the Weinstock family. As you can see, it's quite large. The aim was to expand it so that the dissidents could have their own synagogue, since they no longer, indeed many of them had been excommunicated, expelled from the synagogue belonging to the establishment faction, and they wanted to have their own synagogue. And so Mr. Weinstock got a construction permit to expand his home, but the village put a stop order on the construction, claiming that Mr. Weinstock and his builders were not complying with safety requirements, and indeed were seeking to use this property for non-residential purposes in violation of the village's recently instituted building and zoning code. So this dispute begins as, in some ways, a seemingly a garden variety zoning dispute, but as I'll explain in a moment, it morphs first into a civil rights suit where the dissidents claim that the village is actually discriminating against the dissidents in violation of their civil rights. And ultimately, and this is what I really want to talk to you all about, the theory of the case shifts to become a claim that the village actually constitutes a theocracy in violation of the principle of separation between church and state embodied in the aforementioned Establishment Clause of the First Amendment. Now, before I explain the basis of these different theories of the case, let me introduce you to the interesting and colorful cast of characters who are participating in this suit. So we begin, as I've already said, with the plaintiffs who are Satmar dissidents. Chal Haraidim is the name that the dissidents bestowed on their congregation, which was to function as an alternative to the mainstream Satmar congregation in Kiryas Joel. So that's what Chal Haraidim refers to. Zalman Waldman, Meyer Deutsch, A.H. Weinstock, these are all leaders of the dissident movement. And they're the named plaintiffs. They are standing for a larger group, really a movement inside the village. Zalman Waldman was actually the chief aide to the Rebbitzin, to the widow of the original Rebbe, Joel Teitelbaum, who is still alive, Feiga Teitelbaum. And she was one of the first dissidents, one might say, insofar as she never regarded the Rebbe's nephew as a legitimate successor to her deceased husband. And a circle formed around her, including the Waldman brothers. And that was really the original nucleus of the dissident movement. Joseph Waldman, Zalman's brother, was not a named plaintiff in this suit, but he was a named plaintiff in numerous other suits. This is Zalman Waldman here. He really was a kind of rabble rouser, activist, media savvy, to some extent, self-appointed spokesperson for the dissident movement. And it was Joseph Waldman who first turned to and found what became, in essence, the dissident movement's in-house lawyer, a very interesting man by the name of Michael Sussman, a civil rights lawyer who may be known to some of you. If any of you watched the TV miniseries Show Me a Hero, or if you otherwise have knowledge of the rather famous Yonkers housing discrimination case and school segregation case that was the subject of the Show Me a Hero miniseries, Michael Sussman was the lawyer who very successfully sued the city of Yonkers for discriminating against Blacks in the community, both by confining them, essentially ghettoizing public housing, and thereby producing de facto, if not de jure, segregated schools. So Michael Sussman had quite a reputation. Joseph Waldman turned to him in the early 90s for an earlier lawsuit he filed against the leaders. Joseph Waldman, as I've sort of suggested, was quite the activist. He had a habit of forming committees and organizations to pursue the dissident agenda with names like the Committee for the Well-Being of Kiryas Joel or the Kiryas Joel Alliance. So although he was not officially a party to the suit, like other dissidents who were not named parties, and indeed like the Rebbitzin herself, they're playing an important role in the background in initiating this litigation, as is their lawyer, Michael Sussman. That's the original Rebbe, whose widow is the Rebbitzin I've referred to. But he, by this point in time, is deceased. On the other side of the lawsuit, the defendants are various representatives of the KJ establishment. Named first was Leopold Lefkowitz, who for many years, for decades, was the official elected mayor of Kiryas Joel. He was also really one of the closest associates of the Rebbe, and a mainstay in the leadership of both the Williamsburg and Kiryas Joel communities. But this truly was a titular position. And in point of fact, the actual performance of the duties and the functions and the role of mayor, again, these are elected positions in the village of Kiryas Joel, was performed from the founding of Kiryas Joel up until today by the man who now is the mayor. But for many decades, this is Abraham Weeder. Here we can see he's a mover and a shaker, shaking hands with then President Obama. At this point in time, in the 90s, he's officially the deputy mayor, but he's the real mover and shaker. Indeed, so much so, local journalists were fond of referring to him as Boss Weeder. You had other important figures amongst the village officials, in addition to elected officials like the mayor, the deputy mayor, the member of the board of trustees, which is essentially the town council of Kiryas Joel, unelected administrative positions like village clerk, also very important parts of the leadership. And so it's the village itself and its elected heads, the mayor and the deputy mayor, who are the named defendants. But again, just as in the case of the plaintiffs, where you have the named parties, but they're really standing in for a larger group, so too the establishment represents a wide array of personages, not only those holding public office, be it elected or appointed village officials. You also have the man I mentioned before, Aaron Teitelbaum, the son of the new Rebbe, who here he is in the center, the chief rabbi of Kiryas Joel and his entourage. This is his father, the new Rebbe. And you also have figures, most notably Meyer Hirsch. These are people who play leadership roles that sort of straddle the realms of public, local government officialdom, and they're not religious leaders. They're not the Rebbe or the chief rabbi. Meyer Hirsch is exemplary of the nature of sort of the interlocking systems of public and private, secular and religious leadership that are going to become fodder for Michael Sussman's theory of the case and theory of why the village is operating essentially as a theocracy. That's Michael Sussman's term of choice. Meyer Hirsch is a man who wears many hats. He's a very successful businessman. He runs a development company that was the chief purchasing agent that acquired the land in the town of Monroe that was developed and then settled by the Sottmers. That development company then sort of morphs into a self-standing organization known in Yiddish as the Vad HaKiryah, the village committee, a kind of quasi-public, quasi-private entity that plays a leading role in continuing to acquire and develop property and housing. This is all in, from a legal point of view, a private capacity. But Meyer Hirsch at this point in time also has just been appointed to run the newly established building agency of the town. So he's the one who's supposed to supervise the implementation of the newly enacted building code. And he's also a member of the village's public housing authority. So he plays a major role in, with a variety of public hats and private hats in allocating both public housing and residential and privately owned residential property. Okay. The lawyers are also interesting characters in their own right. I've already mentioned Michael Sussman, the, as it were, in-house lawyer for the dissidents. The establishment has its own stable of lawyers. The lead lawyer in this particular case, defending the village, is a man by the name of Frederick Hafetz, whose photograph I was not able to get. Somewhat interestingly, he was backed up by two then young lawyers, Susan Nicholas and a young Eric Schneiderman. This is 1 year before he runs for Senate, I believe, and he's assisting Fred Hafetz. Also of interest, the man to whom the case is assigned, the Honorable Jed Rakoff. Some of you may be familiar with Jed Rakoff. He frequently contributes essays to the New York Review of Books. He's perhaps best known for presiding over the case against the case with the SEC in the wake of the 2008 financial collapse. More recently, he made headlines with an unusual ruling in a case brought by Sarah Palin, alleging that she was defamed by the New York Times. An interesting figure in his own right, who had just been appointed to the bench. He's a new judge, a new federal judge when this case is brought before him. Okay, so what was Sussman's theory of the case? Sussman's basic theory was that the zoning dispute, remember this whole case begins as with the village's claim that the construction, the dissidents' attempt to expand this residential home into a grand synagogue for the dissidents constitutes a violation of the village's building code and safety regulations. The dissidents see that as nothing more than an attempt to prevent them from erecting their own synagogue, and more generally as an attempt to suppress this dissension in the community and to get rid of them. So Sussman's initial theory of the case is that this stop order, this assertion that the dissidents are violating the building code, that this is an example of a selective application of the building code, and it's just the tip of the iceberg. His theory here is directly borrowed from the quite innovative theory of systemic discrimination that he brought in the Yonkers case, the housing discrimination and school segregation case that I mentioned before. Many of you have heard of the concept of systemic discrimination or structural discrimination, right? The idea that discrimination against a minority doesn't involve single isolated actions by individuals, but you're really talking about systems of systemic inequality. That's a theory and understanding of how discrimination works. That's, lawyers in the audience will know, it's very hard to get courts to recognize that. And going back to Sussman's role in the Yonkers case, that case began as a school segregation case, and Sussman knew full well that many school segregation cases were foundering. These are post-Brown versus Board cases where you no longer have de jure segregation by race in public schools, right? That's been gone since 1954 per Brown versus Board, but schools continue to be de facto segregated. And attempts by civil rights activists and lawyers to change the policies that perpetuated de facto segregation in public schools would typically founder on the defense, as it were, where the public school district or whatever government officials were in charge of the public school district. They would say, we're not responsible for the segregation. It's because the residential housing market is segregated. It's because there's residential segregation. So there's no government action that is responsible for segregating the schools. Sussman's innovative theory in the Yonkers case was to say, well, these two realms are operating together. And actually, the city of Yonkers, by isolating public housing in one part of the city, has played a role in creating residential segregation, and you cannot look at what's happening in the public schools in isolation from the actions that both public and private actors are playing in concert with each other. So it's really a theory about how public and private actors and agencies operate in tandem to perpetuate systemic forms of discrimination and inequality. Sussman says the same thing is going on here. The dissidents are being subject to systemic discrimination. You have public and private actors, secular and religious leaders. They're all part of the aforementioned establishment. Sometimes you have the same individuals wearing different hats. Deputy Mayor Abe Weeder, in his public capacity, is in his private capacity a co-president of the mainstream faction synagogue. Meyer Hirsch, who in his private capacity is a developer and also a member of the synagogue board of trustees, is now on a member of the local public housing authority and running the building commission of the village. So this is Sussman's original theory that the government officials, the village officials, and the lay leaders of the community of the synagogue, who are often one and the same person, are acting in concert. The result is the selective denials of zoning permits, selective denials of tax exempt status for residential properties that contain synagogues or steebles within them, selective denials of public housing units. There were further allegations that the Rebbe, this is the Rebbe, Moshe, had decreed that developers and constructors had to pay building fees, which money was dedicated to support the mainstream synagogue, the mainstream yeshivas. All of these allegations, these are merely allegations, whether these claims are true was the matter to be litigated. Sussman's original theory is all of these actions are operating in tandem with each other with the goal of driving out the dissidents, either driving them away from the village by denying them access to public and private housing, or suppressing them, preventing them from creating their own parallel system of synagogues and schools, and continuing to protest and criticize the mainstream authorities. He did not originally, right? So this was a civil rights action, much like the Yonkers case that he had been involved in before. It was not in the first instance an action claiming a First Amendment violation. That claim only arose over the course of the trial. And it arose because, although Sussman pointed to many alleged facts in support of his claim that the village was systematically and selectively denying permits, tax exempt status, housing units, et cetera, to the dissidents, Exhibit A of the case, that's my reminder to wrap up soon, was a very peculiar law that the village had recently passed, an ordinance known as Local Law Number 2. Remember, the village, it's a fledgling village. The Satmars have not held these kinds of public offices. They haven't been exercising the powers of local government law until very recently. They're learning, and they're learning quickly. And so they've only recently created the apparatus that most villages and towns, particularly suburban villages and towns, have to implement and enforce zoning and building codes. So they've just established this apparatus. They've just enacted an ordinance called Local Law Number 2 for the first time, establishing safety standards for buildings and procedures for enforcing them. And all of this, I'm not going to belabor it, is very typical. You would find similar language anywhere, but there's one very peculiar provision in Local Law Number 2, Section C, which says in essence that if and when someone is found by the newly created Zoning and Building Commission to be using their property or engaging in construction in violation of the zoning and building code, normally, when someone is cited for a zoning or a building code violation, if they want to contest that and say they're not being fairly cited, they take their dispute to court. That's the normal procedure. But Section C says that in the village of Kiryas Joel, whenever there's a dispute over an alleged zoning or building code violation, the dispute is going to be adjudicated not by a court, but by the village board of trustees. That's kind of odd. That's kind of unusual. Sussman puts Deputy Mayor Weeder on the stand and gets him to explain why the village enacted this unusual provision. And as Attorney Sussman coaxes Deputy Mayor Weeder to state while he's on the witness stand, Weeder explains that the reason the village has enacted this quite unusual provision, in essence, substituting the village for a ordinary civil court as the adjudicative body to adjudicate zoning and building code disputes. The reason for that, Weeder, as it were, confesses, is that the Satmars adhere to the traditional religious prohibition. This is a prohibition that originates or was codified in the 16th century in the Shulchan Aruch. The principle that when there are internal disputes in the Jewish community, a case of Jew versus Jew, such disputes should never be taken to Gentile courts. It is forbidden to litigate before Gentiles and in their court. Rather, such internal disputes should be adjudicated by and only by rabbinic courts. So there's a dramatic moment during the trial when Sussman basically gets Weeder to explain, to confess, as it were, that the motivation, the justification, the reason for this strange law is that the Satmars don't want to violate this religious prohibition, this halachic prohibition on presenting Jew versus Jew internal disputes, Satmar versus Satmar disputes to the secular courts. In response to that, shortly thereafter, more courtroom drama, there's a sidebar. The lawyers, in particular, it happened to be the aforementioned Susan Necklace, was arguing for the village at this moment in time. Susan Necklace and Michael Sussman are called to the bench, and Judge Rakoff, referencing Deputy Mayor Weeder's testimony, pretty much reveals that he thinks that's, as in his words, a patent violation of church and state. Now, if we had more time, I want to wrap things up here so that there can be time for questions from you all. But you can see that there ensues a bit of a colloquy in which Susan Necklace says, look, just because elected officials are religious leaders or take their cues from religious leaders. She references Father Drynan, her childhood hero. That in and of itself doesn't constitute a violation of church and state. Judge Rakoff was dismissive of that defense. And he seemed to be indicating his receptivity to the argument that Michael Sussman had not originally made, but that he quickly formulated, that there actually is an Establishment Clause violation going on. And this is a claim that Michael Sussman in subsequent litigation would come to crystallize as the claim that the village actually constitutes a theocracy. That's his term. He introduces that. And as such, the very existence of the village, according to this theory of the case, violates the First Amendment, and therefore the village should be dissolved. Maybe the village would have been dissolved if this litigation had run its course. But no doubt, because they feared that possible outcome, the village lawyers immediately offered to settle the case, right? It seemed that Judge Rakoff had maybe revealed his readiness to go so far as to actually dissolve the village. And in order to circumvent that outcome, the village offered to settle. So settlement negotiations are conducted. There's no lawyers present. This is exactly the kind of rabbinically arbitrated dispute resolution procedure that supposedly comports with the Shulchan Aruch's prohibition on having internal disputes adjudicated by cases. So the court ends in a settlement agreement. Now that settlement agreement immediately broke down. The dissidents immediately went back to filing more lawsuits against the village, pointing to new acts of ostensible discrimination against them. And it's in these subsequent lawsuits, one runs its course from 1997 to 2000. Then there's a new round of litigation making very similar claims from 2011 to 2013. These are all cases were brought by dissidents represented by Michael Sussman, claiming that the village is a theocracy. That's a violation of the Establishment Clause of the First Amendment, and therefore the village should be resolved. But every time such a case was filed, the court, in this last round, it was brought before Judge Rakoff yet again, said, you already made that claim in the original Chal Haraidim case, and you settled that case. And the settlement of the Chal Haraidim case included an agreement not to relitigate this case. In legalese, we call this res judicata. The matter has already been adjudicated, and we're not going to let you adjudicate this issue again. So, very interestingly, the claim that the village is a theocracy was raised not by outsiders, but by Satmars who were opponents of the established leadership. That claim was never adjudicated, largely for technical reasons, because the court deemed any further adjudication of that issue to be precluded by the agreement to settle the case in 1997. So despite repeated attempts to get courts to adjudicate this claim, the courts have repeatedly refused to do so on the grounds that the settlement precludes any further adjudication. I want to close by suggesting that there's a deeper reason why the question of whether the village constitutes a theocracy has never been adjudicated. First of all, there's no clear definition of what counts as a theocracy. Indeed, there's virtually no case law on what constitutes a theocracy as all. The claim that any government entity or actors are functioning as a theocracy, you can search and search in the Federal Reporter, and you'll come up dry. It raises the question: what led Michael Sussman to frame the alleged Establishment Clause violation in this way? Since it's a claim that's virtually never made, there is no case law addressing claims of theocracy. More than that, I think there's really difficult questions attending the question of what counts as a theocracy. It's not just courts that have avoided defining theocracy. I'll end by putting the question to you. It's a question I put to myself. What actually makes a system of government theocratic? Does just having a religiously homogeneous population make a government theocratic? Does the fact that a government official is perhaps a minister or a rabbi, does that make the government that person is a member of theocratic? If so, I think we have to disqualify Reverend Warnock, right? Is enacting laws whose content coincides with the religious laws theocratic? There's really no clear conception available, not just to the courts, but I think to any of us, of what a theocracy is and what distinguishes legitimate forms of religious influence on government from illegitimate ones. So with that, I will close, and I am very happy to take any questions anyone may have.
Amazing. It's so fascinating, and I love the courtroom drama. Before we start with the questions, just because we're coming up on the end of time, I want to make sure that I do announce the second password for the CLE credit. So for those who are seeking credit, don't forget to fill out your digital evaluation form. You need both passwords. The password was given at the beginning. The final password is private. Now you have it. Okay. So we are getting some questions in. I want to start with a broad one, and I, you can address it as broadly or as narrowly as you see fit. But one person wrote that they've read that the Satmar do not really see themselves as citizens of the United States in a full sense, but just see themselves as being sort of temporarily residing here until. Is that the case because I know you have a much broader knowledge of of this community and their legal entanglements, if you want to speak to that, but also to what extent do they see themselves as participating in the legal culture and the political body of the United States?
Mm-hmm. So those are really good questions. And I think they're getting at two different things, but that these two things intersect. So to take the second part of your question first, Anne, this is a community that is in the first instance committed to separating itself from society, right? To not participating in the broader society. It is separatist, right? It is a community that, like many, there are many religious separatist communities. There are many Christian such, there are many Jewish such, and many faith traditions that are motivated by the belief that the world is spiritually impure and corrupt, and that worldly affairs involve the exercise of power in unjust and fundamentally corrupt and spiritually polluted ways, and that therefore the only way to live in a spiritually pure way is to withdraw from worldly affairs. So that's the animating goal, right? And that goes hand in hand with the fact that the Satmars are really committed to resisting modernity, to resisting change, to preserving their traditions. And so there's a deep commitment to insularity. And that goes hand in hand with a belief that we're going, we're not much interested in the outside world. But in rather paradoxical ways that we examine at length in our book, in order to do that, the Satmars have felt it incumbent on them to negotiate with the outside world, to use the levers that are available to them in whatever society, whatever host society they happen to find themselves in. And since the end of World War II has been predominantly the United States, in order to create structures such as the village that will enable them to maintain the insularity that they think is theologically incumbent upon them. That has led for many to a pretty strong form of, let's say, indifference to the outside world. And that goes hand in hand to some extent with the first part of your question. Of course, they recognize themselves as a legal matter, as citizens of the United States, and they will proudly refer to their fulfillment of their legal responsibilities as citizens, as taxpayers. They exercise the rights of citizens, like the right to vote. They perform the obligations of citizens. And at least until recently, there's been, the guiding ethos has not been one of defiance and a refusal to recognize the authority of the government or to enforce legal obligations. Quite to the contrary. That might be beginning to change now, but that's another story. Does that coexist with the belief that, frankly, many religious groups have, that sort of, that, our identity as citizens of the United States, that's an accurate description of our identity and our legal rights and duties in the temporal world, but that's of much less importance than the identity that we occupy in a longer framework than that of the merely temporal world. So to be sure, there's a sense that life in the United States, like life in any particular part of the world, for Jews since the expulsion, is transitory, is temporary, is not necessarily going to last forever. This is not a primary or permanent affiliation, but that does not preclude accepting sort of the legal duties of citizenship.
All right, it is 1 minute past the hour. With your permission, can we take 3 more minutes?
I'm happy to.
Okay, great. And people who need to leave can leave. I want to, thanks for coming, everyone. There's a question asking us to just sort of restate as simply as possible how such a big question was put to rest with one small civil case. And I want to try my hand at saying it in like 2 sentences, and you tell me if I'm right. And then there's some specific questions that people are asking about, like the follow-up, right? Okay, so what I understood you to say is that because the question of theocracy was raised in this civil case, and then that case was settled, and part of the settlement was that they couldn't relitigate it, that issue is now considered to not be able to be litigated again, right? Okay, so a few things. So people are asking, what about this? What about this, right? Like how could it possibly be? So one person is asking if a case was brought to a different entity, like to the school board or something like that, as opposed to the board of trustees, as opposed to zoning, would that still be considered res judicata? Or if a person who wasn't a party to the first suit, so if it wasn't the dissidents, but it was some other entity, would that be a way of getting around it, right? I think that people have a little bit of a sense of like, but this can't be, right?
Absolutely. And certainly the dissidents and their lawyer think, but this can't be. So under the doctrine of res judicata that says if you've already brought a claim and then that claim has been resolved either by a verdict or by a settlement of the case, you can't relitigate issues you raised before that were, reached a conclusion. But if there's a fresh claim, then it's not barred by this doctrine of res judicata. So in theory, all of these, but what about this? Yes, if you could allege a different action, maybe involving different parties or different events occurring to the same parties, or different, the suggestion that, okay, maybe the village, we've lost our chance to get a court to declare that the village is a theocracy. What about the town? Or what about the public school district? In theory, those, if in fact you have facts to support fresh claims, they are not barred by the doctrine of res judicata. And in the more recent litigation, the dissident said, we're bringing fresh claims. These are new, but Judge Rakoff didn't buy it. Now, why didn't he buy it? Was that a correct? I do think judges really don't want to be drawn into this debate. I do think there were grounds for saying this is pretty much the same old. As for the public school district, it would be a lot harder. First of all, I think the village has some pretty strong defenses, even if the claim were allowed to go forward. It's not obvious that the village is acting in a way that meets whatever our definition of a theocracy is. It's even harder to make that case for the public school district, because the public school district, it does not provide religious education. It actually, the only education that goes on in the public school is special education for children with special needs, with profound disabilities. Boys and girls are taught together. So it's not so easy. It's not only that, I think there are pretty profound philosophical debates about what a theocracy is. Whatever it is, however we define it, the public entities are not themselves directly performing religious functions or enacting religious laws. They are facilitating, they are creating services, they are providing services in ways that accommodate and support the private institutions, which are religious institutions in the community, in their endeavor to live this strictly religiously observant secular way of life. So much depends upon whether you accept the distinction between the public institutions of the community, which are nominally and arguably really secular in nature, and the private religious institutions. And it's exactly that dividing line between public and private that Sussman was endeavoring to puncture with his theory of systemic discrimination, and trying to show the ways in which public and private institutions operate in an interlocking fashion.
Terrific. Because you just referred back to it again, can you talk for a minute about the word theocracy? Because we did have a lot of questions about it as well. Partly just why this word rather than thinking about separation of church and state as the standard. So why is this particular idea of theocracy being invoked here, and was it defined by the claimants to explain what theocracy is? Like what are we really talking about here, and how did that get inserted?
Right. The truth is, I don't know the answer, and I'm really curious about it. And actually, our colleague who's here at the center this year, Julie Cooper, sort of brought to my mind how peculiar it was to use that term. Peculiar in the specific sense that it's not a legal term, and it's not a term that is part of the discourse of the Establishment Clause or the Free Exercise Clause or any of the clauses in the First Amendment that address the relationship between the state and religion. We do have a clause that, right, the Establishment Clause says precisely, Congress shall make no law respecting an establishment of religion. No one really knows what an establishment of religion is or what a law respecting an establishment of religion. Like, there's no clear-cut definition of what a religious establishment is. People have intuitions about it. But one thing, having an established religion is not ordinarily viewed as the same thing as being a theocracy. England has an established religion, right? But England certainly doesn't define itself as a theocracy by virtue of officially recognizing the Church of England as the official state religion. So a religious establishment and a theocracy are not the same thing. In this particular case, I mean, because it was never allowed to be litigated, because this idea sort of bubbled up as a result of this like dramatic moment of testimony where suddenly a new possibility appeared, and then subsequent attempts to litigate it were precluded. We've never seen the development of the theory. I'm really curious. I spent a fair bit of time interviewing Michael Sussman, as I was able to interview other lawyers involved with litigation in Kiryas Joel, but I didn't get to, I only belatedly asked him that question, and I haven't heard his answer. I wonder, I think that after the Iranian Revolution, I think that the term theocracy entered into American popular discourse and the American popular imagination and the American Jewish political imagination. And I think that occurred at the same moment in time that American Jews were beginning to worry about the nature of the relationship between state and religion in Israel. And they were observing the ascendance of religious nationalist parties in Israel. This is pure speculation, but I suspect, because so many of not only the Satmars, but so many of the outside interlocutors, the lawyers, the judges who are interfacing with the Satmars are American Jews, secular liberal American Jews. I think that those two things, Iran and Israel, probably are what sort of introduced theocracy as a word and a concept into the Jewish American political imagination, and maybe the American political imagination more broadly at this moment in time. But that's just a hunch.
It is a really fascinating hunch. It's a really strange sort of interpolation of an idea that doesn't really fit. And I think what you're saying makes a lot of sense. We have to let you go now. I want to thank you again. We appreciate so much your being here. It's really, even just this little piece was so fascinating, and I'm sure everyone who checks out your book is going to find the rest of it as well. So congratulations on the book. If you're still here with us, please come back next week to listen to Suzanne Last-Stone talk about Jewish divorce in the American legal system. And yeah, thanks everybody. Have a great day.
Thanks for having me.